If local government is the backbone of our communities, it is its employees who keep things going strong. From police, fire, roads, and utilities, to housing, recreation, libraries, and citizen services. Many of our employees are regarded not only as role models, but also as heroes, and rightly so because of the valuable services they provide. Unfortunately, some employees have made headlines for the wrong reasons. They become subjects of lawsuits dealing in such areas as harassment, discrimination, and safety and violence. These are basic civil rights, and we have a no-tolerance policy against violations and violators. And that's where municipal attorneys like myself come into the picture, helping elected officials and professionals to deal with these important issues. So please join me now as I meet with the municipal manager, the police chief, the fire chief, and the executive director of the local authority.
You know, and I want to thank you all for coming this morning. As you know, we've had incidents of wrongdoing in the workplace in many parts of the state, and these incidents are unacceptable. So I thought it might be helpful to have the municipal attorney talk to us about precautions we need to take.
Well, thank you, and good morning, everyone. To begin understanding this issue, federal and state law covers such important areas as discrimination, safety, violence, and harassment. And this governing body has a no-tolerance policy towards these violations of basic civil rights.
I really appreciate you coming to this meeting. My officers and I have always believed that we were immune from personal legal liabilities when we're on the job. Getting sued is about the last thing we can afford to think about when we head out on a call. We put our lives on the line, and we thought that as government employees, we couldn't be sued.
My firefighters and I feel the same way. When you're called out at 3 in the morning, the last thing you want to be thinking about is being sued.
And I understand that. And while as a government employee or volunteer, you do enjoy many legal protections, however, you can be sued if you violate someone's civil rights. That's a whole different area of the law. And there's no absolute defense, such as immunity, against a civil rights claim.
Isn't this covered by the insurance?
As much as legally possible, but under law, insurance often cannot cover the punitive damages awarded when someone deliberately and knowingly violates someone else's rights. In other words, in some cases, you can be held personally liable. However, a lot of these problems can be avoided simply by using common sense.
You're right about that. Too often, petty squabbles build into a big feud, and the police department can be tied up in lawsuits for years. A lot of this can be avoided if we just slow things down and let cooler heads prevail.
Didn't these laws originally focus on personnel decisions like hiring, terminations, promotions, and discipline?
Exactly. You must be very careful to make personnel decisions in a non-discriminatory way. However, today, these laws are far broader.
For example?
Well, harassment lawsuits have increased substantially because most people are no longer willing to tolerate bad behavior. You know, at one time, someone who was the target of jokes or other intimidating conduct just had to take it. No more.
It's important that we communicate this message to everyone involved in the town's organization. Under no circumstances should you make jokes, use nicknames, pick on someone based on their race, religion, national origin, age, disability, gender, or sexual orientation.
Come on, there's nothing wrong with a little give and take now and then.
The problem is you never know when the line is crossed and the jokes become offensive. I thought the person didn't mind is not an excuse. That's why we insist on the no-tolerance policy.
Do these laws extend to volunteers?
Yes, the no-tolerance policy towards offensive jokes and similar harassment also applies to volunteers connected with the municipality.
I heard that a town and a few of its firefighters were sued when they supposedly harassed a gay couple who lived next to the firehouse.
You know, the behavior of those firefighters you're talking about was unacceptable and reflected very poorly on all firefighters, unfortunately. But there really is a valuable lesson to be learned here. We not only have to be strict about harassment among people within the organization, we also have to be concerned about harassment towards the general public.
How about employees and volunteers dating each other? Do we have to put the brakes on that?
Well, There's a rule of reason here. Certainly there is nothing wrong if people would like to date, but you are correct that the no tolerance policy does extend to sexual harassment as well. Now, specifically, it refers to making unwelcome sexual advances, making remarks that are offensive, engaging in physical contact with a fellow employee or a volunteer, and creating an intimidating, hostile, or offensive environment by such conduct. In judging if something is offensive, you have to ask yourself this. Would you want your family members exposed to this conduct?
You know, I also noticed that some of these lawsuits, where they're brought by people who claim to have been disciplined or harassed for blowing the whistle.
Probably the most basic protection any citizen has is the right to bring wrongdoing to the attention of the appropriate officials without fear, and this is very important, without fear of retaliation.
Just who is considered a whistleblower?
That's a very good question. Now, under the various laws, a whistleblower could be an employee, a volunteer, or a member of the public who complains in good faith of discrimination, safety issues, and harassment, including sexual harassment. Specifically, that would mean disclosing or threatening to disclose anything that the individual reasonably believes is illegal, or it could deal with providing information to an investigation into any violation of law or regulation. Now, it could also mean objecting to or refusing to participate in any activity that the individual, again, reasonably believes is illegal or is incompatible with a clear public policy mandate concerning the public health, safety, or welfare.
It seems to cover everyone.
Well, almost. To be considered a whistleblower, the individual must actually bring the alleged wrongdoing to the attention of the proper authorities. And this is why we are required to regularly communicate the complaint procedure to everyone concerned.
Can you require all complaints in writing?
No. While we do encourage that complaints be made in writing, verbal complaints are sufficient under the law. Yeah.
What constitutes retaliation?
Well, certainly any official act, such as suspension, termination, demotion, but it also includes anything that could have the effect of discouraging someone from speaking out. In one case, an individual was teased by the other members of the department after complaining about something, and the courts ruled that this teasing was considered retaliation because the department didn't take sufficient steps to stop it.
In other words, this is another type of illegal harassment?
Exactly. Further, if you are aware of retaliation, harassment, or other violations of civil rights, you cannot ignore the situation, even if the victim hasn't complained yet.
What do we do if we receive a complaint?
Well, first, don't go running to the person who's been accused of the wrongdoing and ask if the complaint is true. The community has an official investigation procedure, so what you have to do is follow that procedure and then take the complaint seriously.
Makes sense. You don't want the accused person to confront the accuser. Could make the situation worse.
Exactly.
What if the complaint's false?
Well, if the person who made the complaint knew the complaint was false, then that person is subject to the appropriate penalties for knowingly filing a false complaint. The whistleblower law only protects people from making complaints in good faith. You can't use the whistleblower law to harass someone. That violates the other person's civil rights.
We've adopted the 5-part program required by law to protect employees, volunteers, and members of the public.
And the courts are very specific on this. We are required to adopt a clear policy prohibiting discrimination, harassment, and other violations of civil rights. Establish a complaint procedure. Provide training to both supervisory and non-supervisory personnel. Monitor the program for effectiveness. And communicate management's unequivocal commitment to enforce this policy.
Any other advice?
Yes, be proactive. If you see someone heading in the wrong direction, warn them before something gets out of line, and always lead by example. Be committed to the standard of no tolerance and the standards set by the courts. And while much of this is common sense, as I mentioned earlier, if you have any questions or concerns, please talk to me, or you can talk to your own attorney.
Very good. Thanks so much for your time and your expertise. I, for one, have learned a lot. And for the rest of you, thank you so much for attending. And if you have any questions later on, don't hesitate.